Donald Trump could be in some hot water with his Mar-A-Lago resort in Florida. According to a legal expert, if he's found guilty of civil fraud by New York Attorney General Letitia James, he might be saying goodbye to his beloved property. It turns out that Trump may have jeopardized his protection from creditors under Florida's homestead exemption by claiming Mar-A-Lago as his primary residence, while using it as a fancy private club. Well, Trump better get ready to prove that Mar-A-Lago is truly his home, because there are a bunch of hurdles in his way. One would expect Letitia James to argue that a members-only club with guest rooms shouldn't count as a residence, and if only part of the property is considered as residence, things get even trickier for Trump. Better lawyer up, Donald. Golden also emphasized that Trump's legal woes could become a battleground between New York and Florida laws, potentially leading to a showdown at the Supreme Court. Picture it now. Two states duking it out over inflated property values and deflated egos. In all seriousness though, this civil fraud lawsuit filed by James in August 2022 is no laughing matter. It accuses Trump and his adult sons of playing fast and loose with the numbers to score favorable loans, tax breaks, and other perks. And the price tag? A hefty $250 million in damages and a lifetime ban on Trump doing business in the Empire State. Things took a turn on Friday when Judge Arthur Engoron dropped the hammer, ruling that Trump was indeed liable for fraud. Ouch. Engoron even went so far as to yank the business licenses for Trump Organization properties and appoint an independent monitor. In the unfortunate event that Trump is held responsible for the damages, he might have to kiss goodbye to some of his fancy properties. Say adios to Trump Tower in Manhattan, wave goodbye to Trump International Hotel and Tower in Chicago, bid farewell to Trump National Doral Miami, and give a tearful farewell to Trump National Golf Club in Los Angeles. But the one that really hits close to home is Mar-A-Lago, the crown jewel of Trump's real estate empire. This luxurious 20-acre estate with its 128 rooms, spa, golf course, and beach club is valued at a whopping $160 million. According to Forbes, losing Mar-A-Lago would be a serious blow to Trump's ego and bank account. It's the place he bought back in 1985, turning it into a swanky private club in 1995. And it's not just a residency, it's a political playground where he's been making moves since leaving the White House. So if Trump finds himself in hot water, he might have to say goodbye to his beloved Mar-A-Lago oasis. Although his residency at Mar-A-Lago has caused quite a stir, it's no surprise considering how it all started. You see, back in 1993, Donald Trump made an agreement with the Palm Beach Town Council that he would only stay at the club for a maximum of 7 consecutive days and 21 days per year. Well, it seems like he may have forgotten about that little arrangement, because he's been exceeding those limits ever since. The council hasn't done much about it yet, but they could take action if Trump loses his homestead exemption. And if that wasn't enough, our former president is also tangled up in not 1, not 2, not 3, but 4 separate criminal investigations. We're talking about business dealings, taxes, campaign finance, and even national security. In fact, one of those investigations involves the not-so-secure storage of classified government records at Mar-A-Lago. But of course, Trump insists he's done nothing wrong, and calls it all a witch hunt, orchestrated by his political enemies. It's no wonder that even the U.S. Department of Justice is concerned about his famous social media outbursts. In fact, the special counsel has requested protections for jurors and prospective jurors ahead of Trump's trial in his election subversion case. Just another day in the life of our tweet-happy ex-president. In a hilarious turn of events, it seems that Smith just can't handle Trump's witty comebacks and snarky comments. Smith has had enough and is now requesting an order to silence the former president. Talk about a sore loser. Smith's team is accusing Trump of spreading disinformation and harassing everyone involved in the case. But Trump's legal team is not backing down, arguing that this order would step on their client's right to free speech. It's a battle of words and social media tactics, and who knows what kind of jury judging shenanigans Trump will come up with next. Smith has also hilariously raised concerns about Trump's ridiculously outlandish public comments, which he says have the potential to completely ruin the pool of potential jurors in Washington, D.C. I mean, seriously, who wants a juror who has already been influenced by Trump's shenanigans? This issue of jury protections has become super important in high-profile cases, especially when it involves famous people. Just look at the trial of that former Minneapolis police officer, Derek Chauvin. who was found guilty of brutally murdering George Floyd. The jury in that case had to be locked away and kept anonymous because of fears of threats and intimidation. Now, in Trump's election subversion trial, they're requesting jury protections because social media could seriously mess up the whole judicial process. Trump's use of social media as a tool of intimidation, as noted in Smith's brief, might have a chilling effect on jurors and potential jurors, perhaps affecting their decision-making and eroding the fairness of the trial. The need for juror protections in the Trump trial serves as a reminder of how crucial it is to maintain an unbiased, fair, and free of outside influence legal system. Despite being a relatively recent issue, social media's influence on the legal system is anticipated to become more crucial in high-profile cases in the future. As a result, it will be crucial for courts and legal professionals to continue debating these concerns and formulating plans for safeguarding the judicial system's credibility in the modern day.